Be reading from this transcript here. This is a case of a late cancer patient who died in Berkeley in 2020 and made Yehuda Ferris, who is a leader of CHABAD of the East Bay for 45 years, whose wife owns a ton of real estate. Both of them always purchase $1 million properties here, every couple of years, about $8 million in 2022. So the man died of cancer who worked for them for many years. He had cancer 6 years. He left a trust. He said, give my 3 poor elderly Jewish siblings a lien on the property with interest until paid in full, would be about $150,000 right now, or a lien, or part ownership of the property. Well, Yehuda Ferris and his attorney, if he is an attorney, out of Petaluma, William John Rogers. He's got a lot of different names. I wonder why. And his license is 154219. So Yehuda Ferris gave his lawyer $57,000 in the trust matter, but he didn't give the siblings anything but $4,000 5 years ago. So this is a case where poor elderly Jewish siblings got nothing when their brother died after 6 years of cancer, but the lawyer got $57,000, and Yehuda Ferris got a lot of money. The lawyer wrote himself in as a beneficiary, which is forbidden. Okay, so here's the transcript, and I just like to read it, and the screen may go blank for a while, but okay, here we go. It says, good morning. I'm just going to read. We won't be able to see it. Hold on. It says, good morning. This is a true transcript. You just have to bear with me. Good morning, calling the matter of the Abalafia Trust dated August 26, 2019, and this hearing was on August 19, 2024. I think both parties have petitions, but for these purposes, could the petitioner state their appearance, please? Margulies. All right, Mr. So-and-so is here on behalf of the respondents. William Rogers, license number 154219, California license, attorney's license. On behalf of the respondents, Rogers, good morning. Your Honor, on behalf of the trustee, Yehuda Ferris, Rabbi Yehuda Ferris, well, I'm not so sure about that, who is present. Mr. Horn, Briar Horn, okay, let me fill you in, folks. They sold the person who died his half of a $2 million house to his 2 non-Jewish daughters who never saw him once in 6 years of cancer. But the trust strictly forbids them from purchasing it. It says that they can only get 50.1%. So this is a case where it seems like as if the court totally disregarded the terms of the trust. Yehuda Ferris totally ignored the terms of the trust. Even the daughters, if they had any moral fiber, they wouldn't have accepted the purchasing half of the house because it's illegal for them to do so. But, there's no honor among thieves. And who are the losers here so far? I mean, there's still a God and the case is still valid, but the 3 siblings got nothing and everybody else got everything. Why did they sell the half of the house to the daughters for $80,000? Because Yehuda Ferris's wife wants to sell the property. That's what she's going around bragging to everybody. In fact, she sent a text to the brother saying, well, we didn't really sell the house, but if we can get you out of there, we're going to put it on the market and make some money. And then so they sold the property and they fought an eviction against the man's brother. In the middle of the COVID pandemic, they started an eviction action. And they told him, get out in 2 months or you're never going to get any of your inheritance. And he's thinking, okay, either I'm going to get out and risk death at COVID because there's nowhere to go and nobody's renting in the middle of COVID, or get disinherited. Well, so now they fought him for a year. Then he's now not there. Now they sold the property for $80,000. There was $100,000 in the bank. Now there's $20,000. But yeah, they gave all the money to their attorney. Again, no honor among thieves. So here we go. Morning. Okay, Briar Horn represents the 2 daughters who stole the property from the trust illegally for $82,000. If you can read English, the trust says the daughters only get 50.1% of the property. Period. End of story. No ifs, ands, and buts. Well, they sold it to him anyway. And then they got this green thumb attorney representing them. So it's Briar Horn on behalf of Maxine and Flora, the daughters who never saw their father in 6 years. They just admitted. If you listen to this entire transcript, you're going to hear them say that. So the judge says, all right, Mr. Horn, your clients are parties. It's a fine for them to appear remotely. If you are going to be calling them as witnesses, then I remember I need a declaration. Yes, declarations were submitted on Friday. I have copies here. I see nothing in the Register of Actions. They were served on the other parties, and they were submitted to the court on Friday. Were they filed? Yes. Submitted for filing electronically, as I have copies here if you'd like to see them. Yeah, I'd like to see them. I reviewed the declaration, and the court will accept these declarations and allow them to appear remotely. Okay. Then their attorney, who's representing them in the theft of trust property, says, all right. And so the first issue we need to address is the 1601 issue. So the court attempted to review the case that you referred to. Mr. Marley's estate of Young, that does not exist. The court did find one case that was on point in regard to the form. That is Heroic versus Wilkins, 84 California Appeals Court, 4th District, 208, what appears to be the guiding principle for the court interpreting this particular statute. So, Mr. Rogers, I wasn't finished with my presentation on Friday. I'm sorry, said the judge. I wasn't finished with my presentation. I had a lot more material, and you said, see you Monday. Okay, did you file something with the court? The man's brother says, no, I just have my notice. Okay, to the extent that you're going to be referring to any case law, it's really important that you file with the court ahead of time so that the court can look at it and consider it. It is not only case law, it's statements. So if it's an argument, that's fine. But Mr. Rogers, this is your issue and Horn's issue, and I'll allow you folks to proceed on that. If I may address this case in a broader sense, the motion for judgment on the pleadings is Horn's motion, and I would probably, if you can speak louder because I can't hear you. The acoustics here are probably not the best for a voice as low as mine. And Madam Court Attendant, does Mr. So-and-so have the assisted listening? Yes. And I just was asking you to speak more clearly. It was kind of muffled. That's the deep tone of my voice. I don't know if I can change it. Is this any better? Maybe a little slower. All right. So the judge says, all right, that's the court. That's the court's job. Just let me know if you're unable to hear. It's very difficult to understand you, by the way, so don't take offense, but all of you need to talk more slowly and carefully. So again, this is Mr. Horn's motion, but I have a sense, and I think the attorneys might have a sense of where this case is going. We have this motion for judgment on the pleadings. This whole matter could take a couple of minutes, and I think this case, which has been going on now for 4.5 years, of course it has. They disinherited 4 elderly Jewish siblings, and they expected them not to have a lawyer and to just get the case crushed. Well, no, they want their share of the trust. It was their brother that died. It was their brother that left them something in the trust, and it was this man's client who took everything from him and gave him nothing. And he's complaining about his 4.5 years. Yeah, because they all live in mansions. Okay, here, I don't mean to be a running commentary. If we have this motion for judgment on the pleadings, the whole matter could take a couple of minutes. And I think if we end this case we could end this case in a 90-second hearing. It's going to be premature death to this case. I have a statement that I'd like to make. It started off being an opening statement for trial, but then I switched it to maybe being a statement if we're starting a motion. Maybe I could say it at the beginning of the motion, but I think there are things that need to be said for all the parties involved who have endured 4.5 years of this. What about the people that got disinherited 4.5 years ago? They don't care to you. You only care about your client who disinherited them. And I'm afraid I want the court's leeway, assistance, to allow me to make that without starting the whole trial. So maybe we could start the motion, have the motion, and maybe opening statements without ruling on that motion yet. I feel like the court has probably read my pleadings. I've tried to be really concise. I'm going to provide a concise statement of 4.5 years boiled down to 10 minutes, and I'd like to find a way to say that, Your Honor. So the judge says, all right, so the court has no issue whatsoever if you'd like to do an opening statement and then allow the court to consider the motion on the pleadings. There's no problem with that. All right, so let's talk about the motion for the judgment on the pleadings. So when the court ruled on that motion, it appeared the court said there was merit to the motion, but we didn't have sufficient information about when the cancer patient's brother received the notice and wanted to hear some evidence. And so I understand that Rogers' office served the notice. That is why I turned to him this morning, because the court does not want to hear some evidence in regard to that document and not have that document in front of us. So the lawyer for the two daughters who stole the property, violating the trust, they didn't see their dad for 6 years of cancer. He says they can only get 25% of his half of the house. The trustee, who is opportunistic, and his wife has been wanting to sell the house since the man got diagnosed 10 years earlier. This guy's representing the daughters who purchased the property even though they know it's a violation of the trust, because a 5-year-old kid could read the trust and see what the trust says. Okay, so their attorney, Briar Horn, license number 330219 of Brightwork Law, said, well, having said that, Maxine and Flora Zippen would like to call Rogers to the stand. All right, am I going up there? Since you have a good seat, why don't you just stay in the seat that you're in? But you'll be hearing them okay. So the man's brother, the man who died's brother, says yes. Why don't you stay where you are? And Madam Clerk, can you swear Mr. Rogers in? Having first been duly sworn, testifies as please be seated and state your name for the record. William J. Rogers. All right, Mr. Rogers, you probably haven't testified many times before, but you'll probably question witnesses. If there are any witnesses in the courtroom that, other than parties who intend to testify, they need to either leave the courtroom or log off at this time, otherwise you'll not be permitted to testify. If you're a party, you can certainly stay. Procedural question. When they're finished, when the questioning is done, may I ask them this time, or is that another time? May you what? Question Rogers. Is that another time? Because I have questions for him. You can question him within the scope of the questions that are asked on direct. Okay, so is there ever a time in the trial when I'll be able to ask him questions? Again, you can question him about the things he's asked about in direct. You can't ask him anything about anything else at this time. So someday. All right. And so I was saying, Mr. Rogers, just listen to the questions, make sure you understand it, and if you don't, let the attorney know, whoever's asking, and I'm sure they'll be glad to clarify. Direct examination by Mr. Horn of his partner in, they work together. This is the lawyer who sold the $1 million worth of property out of the trust on behalf of the real estate millionaire Yehuda Ferris, and that's Mr. Rogers, and then he's interrogating the man who they sold the property to for $80,000. It's called straw men, so they can flip the house. Mr. Rogers, so Briar Horn asked Mr. Rogers, can you please introduce yourself? Yeah, I'm William Rogers. William Rogers, are you a licensed attorney? Yeah, since 1991. And can you please explain to the court your involvement, if any, in the trust of Abulafia? Yes, I'm the attorney for Rabbi Yehuda Ferris, who is the trustee. And did you serve notification of the trustee on the beneficiaries of the Abulafia's 2019 trust? I mailed the notice of administration. These are good old boys talking here. Trust me, ladies and gentlemen. All right. Will the record show that I'm handing the witness a document marked as Exhibit 71? All right, the record will so reflect. Do you recognize this document? I do, and what is it? It is the notification by trustee pursuant to California Probate Code 16061.7. Is this a true and correct copy of the document? Yes, it is. Your Honor, I ask the document be marked Exhibit 71 to be admitted into evidence. Any objection? No. All right, then the notification by the trustee pursuant to Probate Code Section so-and-so marked as Exhibit 71 is admitted into evidence. Mr. Rogers, is that your signature? That is my signature. Can you describe the second and third pages of the document? The second page is a proof of service. The third page is entitled my own handwriting, Schedule A of POC. There's proof of service and the address that it was mailed to. After you mailed notification, did anything occur to you that you would believe that he received the notice? Nothing contrary would lead me to believe that he didn't receive the notice. The notice was not returned in the United States mail, marked undelivered, so I assume it was delivered. Thank you. And for the notification, oh God, it's a long one. And for the notification by trustee exhibit 71, is that the only notification that served on the trust beneficiary at the time? It was the first notification that I gave to the beneficiaries. And any person file any trust contest on claims against the trustee within the 120 days? No. Are you aware of anything contested trust after 120 days? Yes. And who contested the trust? Noam Ziprin, also known as Noam Margulies. And do you know the approximate date that he first contested it? I don't, but I know it was very close to 2 years after my calculation of the running of the statute of limitations. With looking at the first page of Mr. Margulies' petition to contest the trust, refresh your memory, probably. Then their attorney for the thieves said, will the record reflect? And I'm handing a document to the witnesses. All right, the record will so reflect. Oh, and do you recall on what date Mr. Margulies filed the action seeking to invalidate the trust? Well, the petition says, I see a court file stamp on July 29, 2022, which was 2 years after 120 days after I served notice of trust administration. No further questions, Your Honor. All right. The question within the scope of direct. Yes, go ahead. Before I begin, I don't know if it's too late, but when you asked if I objected to the notification, I was not aware that he was including a proof of service. If I could go back, I would object to this proof of service, but I don't really recall that document. But I do have some questions on direct. Court, why don't you ask some questions? Okay, bear with me. Give me a second. This is the man's brother, the man who passed away's brother, interrogating the lawyer for the guy that sold the property for $80,000, but it was worth $1 million. So the brother says, when you send out that notification, you'll have to hear, did you include a copy of the original trust you gave to Rabbi? I mean, I don't know if he's a rabbi, but I'll take it back. Yehuda Ferris. Did you include a copy of the original trust in the amended version that you sent? Well, I can see from this proof of service that I have a... hold on, ladies and gentlemen. Handwritten notification which reads that I served the following attached documents. First, it's the printed notification by trustee. That's my handwriting. It says with a copy of the trust, and I circled it, not to interrupt you, but that was the first or the second trust. That was the August 26th trust. All right. And if it's within the scope, I mean, if the judge, Your Honor, you tell me, I'd like to bring them to the court's attention. So, Mr. Margulies, this is the time for you to ask your questions. Yes. Are you aware that in the original trust, there's a statement that says, you wrote this trust, Mr. Rogers. It says on page 2, it says, during the lifetime of the settlor, the trust may be revoked in whole or in part by any instrument written signed by a... Okay, I gotta stop this for a minute.